They called for help. The system looked away. 2 little boys, 2 shattered families, 2 preventable Florida tragedies. 1 broken system that failed them both. Children are dying because of systemic failures. Lobbyists serve special interests instead of addressing the root problems. This is not a political issue, it's a matter of life and death. Temporary fixes aren't enough. It's time to confront the crisis at its core. Greyson's story is one no parent should ever have to tell. His mother did everything right. She called law enforcement. She told them she feared for her son's life. She filed an emergency motion in court. She begged for help. She warned everyone that something terrible could happen. But like far too many parents in Florida and across the United States, when she said the word custody, law enforcement stopped listening.
Custody. So the judge will have to decide on the custody thing for you.
Officers dismissed her case as a civil matter and directed her to the courthouse.
I hope my son is safe. I really don't know his mental stability here. I'm really worried.
Yeah, the courthouse is just down the street here, so you're super.
They did not apply Florida's criminal statutes. They did not conduct a domestic violence lethality risk assessment. They did not investigate. In 2021, Greyson's life was taken by his father in a murder-suicide, just 12 hours before a judge denied the mother's emergency motion. The court rejected her urgent request after Greyson had already been killed. Later, the court issued a public statement claiming that law enforcement should always be contacted. But law enforcement was contacted and failed to act. This wasn't a miscommunication. It was a systemic failure and a preventable tragedy. And this story is not uncommon. Nick Hutchins fought for 7 years, from 2016 to 2023, in the Florida family court system, trying to enforce his court-ordered parenting plan. He wanted to be part of his son Aiden's life. He had a court order that promised him visitation rights. But his ex, Brandy Hutchins, repeatedly violated the court order by refusing to let Aiden visit with his father. While Nick lived in Maine, he drove to Florida over and over again hoping to see his son, only to be turned away. In August 2023, after years of legal battles and many thousands in legal fees, a judge finally granted Nick primary custody of Aiden. The court ordered Aiden to live with his father in Maine and attend school there. Brandy was granted scheduled visitation for holidays and summer breaks. But Brandy refused to comply, even after another explicit court order instructed her to return Aiden to Nick. Nick obtained an emergency order giving him permission to take custody. A judge then ordered Brandy to turn Aiden over at the Polk County Sheriff's Office by 6 p.m. on Friday, August 25, 2023. She didn't show up. Only after the deadline passed did law enforcement act. Deputies went to Brandy's residence. By then it was too late. Inside the home, police found Brandy dead, Aiden dead, and Brandy's other child from a previous relationship also dead. All victims of a murder-suicide that could and should have been prevented. Let's be clear, this was not a custody dispute. This was parental kidnapping. It was a crime, under Florida law and under the Constitution. Florida's criminal laws makes this clear. Florida Statute Section 787.03, Interference with Custody, makes it a criminal offense to knowingly violate a custody or time-sharing order. This is not a civil matter. It is a chargeable crime. Florida Statute Section 741.28, Domestic Violence, defines domestic violence as more than physical abuse. It includes threats, coercion, stalking, kidnapping, and actions that create fear for safety. Florida Statute Section 39.01, Child Abuse. The statutory definition of abuse includes any willful or threatened act that results in, or is likely to result in, physical or emotional harm, significantly impairing a child's well-being. Florida Statute Section 741.29(6) e. Lethality Assessment, requires officers responding to domestic violence to ask specific questions assessing risk of serious harm or death. In Greyson's case, law enforcement failed to follow this law. They did not conduct the required assessment. The following legally required questions were never asked. 1. Did the aggressor ever use a weapon against you or threaten you with a weapon? 2. Did the aggressor ever threaten to kill you or your children? 3. Do you believe the aggressor will try to kill you? 4. Has the aggressor ever choked you or attempted to choke you? 5. Does the aggressor have a gun or could the aggressor easily obtain a gun? 6. Is the aggressor violently or constantly jealous, or does the aggressor control most of your daily activities? 7. Did you leave or separate from the aggressor after you were living together or married? 8. Is the aggressor unemployed? 9. To the best of your knowledge, has the aggressor ever attempted suicide? 10. Do you have a child whom the aggressor believes is not the aggressor's biological child? 11. Has the aggressor ever followed, spied on, or left threatening messages for you? 12. Is there anything else that worries you about your safety, and if so, what worries you? These questions are not optional, they are required by law. Yet none were asked. The officers told Greyson's mother to go to the courthouse. They brushed her off. When law enforcement fails to uphold court-ordered parenting plans, it undermines Florida Statute Section 787.011b and 787.03, as well as violates constitutional guarantees. Constitutional violations. The Florida Constitution, Art. I, Section 9, and the U.S. Constitution, Amend. 14, both guarantee due process, while the Florida Constitution, Art. I, Section 2, and the 14th Amendment guarantee equal protection under the law. This means, one parent cannot remove another parent's rights without a proper hearing. See Troxel v. Granville, 530 U.S. 57, 2000. Law enforcement is required to enforce lawful court orders. Failure to do so may violate due process and can constitute neglect of duty under Florida law, Section 839.24 FLA-STAT. Law enforcement does not have authority to interpret the law, that is the role of the courts. Officers may apply the law, but adjudicating rights or interpreting the scope of legal orders is solely within the judiciary's domain. This separation of powers is foundational to our democracy. When law enforcement refuses to act, they violate both the law and the Constitution. Greyson and Aiden should be alive today. Their deaths were not unforeseeable or random. They were the direct result of a system that refused to enforce the laws designed to protect children and families. This is not a gender issue. This is not a political issue. This is a public safety crisis. This is a constitutional failure. We must act. We demand enforcement of existing custodial interference and domestic violence laws. Mandatory lethality assessments in all high-conflict custody cases. Law enforcement training on family abduction and coercive control. Accountability for courts, law enforcement, and public officials who fail to protect children. Greyson and Aiden deserved better. The next child still has a chance. Don't let another parent bury their child because no one would listen. Speak up. Share this. Demand change before it happens again.
But we all know law enforcement will not get involved. They say, we tell our clients frequently, if you call, they're going to say it's a civil matter and they're not going to get involved.
Law enforcement do not get involved. Even if it rises to a criminal level, they do not get involved. And in many times, they are also discouraged by their superiors from getting involved.